Good day, my wonderful and amiable listeners. I bring to you another news. The news headline: How Attorney General Malãmi manipulated Buhari to approve payment of $350 million to Ned Nwoko, other Paris Club consultant despite fraud alerts. The news in full. The Attorney General of the Federation and Minister of Justice Abubakar Malãmi in 2018 tricked President Muhammadu Buhari to approve $350 million out of the total sum to some consultants, despite the repeated warnings on the genuineness of the $478 million judgment debt said to be owed by the state and their local government with respect to the Paris Club refunds. This regarding the warning, including a report by the Economic and Financial Crime Commission (EFCC) against the legitimacy of the debt. Malãmi, in a letter to the president dated 9 October 2018, said his office had worked out disbursement ratio of this amount to the appropriate beneficiaries. The controversial debt arose from the various court judgments ordering that some contractors and consultants be paid for certain services and projects executed for the various states and the 774 local governments. Some of the claimants were said to be consultants who helped the state and local government to secure recovery of funds over-deducted from their allocation between 1995 and 2002 to the service, then London and Paris Club loans. Your Excellency, kindly recall my previous correspondence addressed to the Chief of Staff to the President dated 11 July 2018 and 1st August 2018, copies of which are attached herewith, and Annexure 1A and 1B, on the need to settle third-party claims in the respect of the above subject matter. Part of the letter written by Malãmi to President reads: Your Excellency subsequently approved the accommodation for the settlements of the third party via letter dated 29 August 2018 with reference number SHCOS 08B848 addressed to the Honorable Minister of Finance, a copy of which is attached herewith in Annexure 2, consequent upon the approval of the Honorable Minister via letter dated 14 September 2018 with reference number FMF HMF CBN PC Final 1 2018, directed the Governor of the Central Bank of Nigeria to set aside the sum of $350 million for settlements of legal consultants fees, etc. A copy of this letter is attached herewith as Annexure 3. I wish to draw Your Excellency's attention to the fact that in the initial refund made to the state, the Honorable Minister of Finance directly instructed the Central Bank of Nigeria to pay all the sum of $86,546,526.65 as consultancy fee and $19,439,225,871.11 naira as legal fees to NGF accounts. The relevant letters are attached here with as Annexure Roman figure 7A and 7B. The above payments resulted in EFCC investigation, prosecution, and forfeit actions. Please see attached media report in Annexure 4. Argon local government did not benefit from the above sums. It is also instructed to relate that the instant presidential approval is premised solely on the need to settle outstanding court judgment orders arising from the Paris Club refund in respect to the local government to avoid future judgment debit liability on the federal government of Nigeria. I wish to buttress the above by making reference to paragraph 10, Roman figure 9 of the letter of the Honorable Minister of Finance addressed to Your Excellency and dated 5th July 2018 with reference number FMP HMF SHPRS Final 2018, which clearly states a court order has been secured with regards to local government refunds. A copy of this letter is attached to Annexure 2. I wish to further make references from the Chief of Staff to the President dated 28 June 2018 with reference number SHCOS 08B782 addressed to Honorable Minister of Finance, copied to me, attached herewith as Annexure 5, whose paragraph 1F stated the President directive to me as follows: directed that in relationship to court case insinuated by the 235 Local Government Council against the federal government, the Attorney General provides a legal opinion as to constitutionally and sovereign implication of any third-party consultant, such as Liners International Limited, being eligible for 20% if judgment sum as payments which are to be deducted at sources. This above also shows beyond doubt that the third-party claim for which presidential approval which suit is in relation to the judgment obtained in the case instituted by local government councils and not states. Your Excellency, is respectfully invited to note that 1. Presidential approval was granted for the sum of $350 million for settlement of the legal consultancy fee, etc., based on recommendation made by the Federal Government of Nigeria legal team. 2. My office has worked out disbursement ratio of this amount to the appropriate beneficiaries. 3. In the initiate refunds made to the state, Nigerian Government Federation was paid the sum of $86,546,526.65 consultancy fee and $19,439,225,871.11 naira as legal fee, while Argon legal and consultancy fees remain unsettled. 4. Both Nigerian Government Federation and Argon had previously issued letters of no objection to direct payment. Argon legal and consultancy fee to Liners International Limited, copies attached Annexure 6 A to C. 5. All beneficiaries are to submit appropriate letter of understanding accepting the payment as final settlements of their claims. 6. EFCC is better being directed to initiate criminal actions against Royal Nigeria Limited, Prince Nicola Ukachukwu and Ted Edwards based on the report of its earlier investigation for the extradition of Ted Edwards. Notation 8. In view of the foregoing, Mr. President is respectfully invited to 1. Note that the Honorable Minister of Finance, Accountant General of the Federation, and the Governor of the Central Bank of Nigeria are to effect the disbursement of the approved sum of $350 million in accordance with disbursement mandate to be issued by the Honorable Attorney General of the Federation. It had, in a series of reports, exposed wide-ranging legitimacy issues, including non-execution of agreed contracts and backdoor deals raised against the indebtedness from various quarters. One of the beneficiaries is one Dr. Ted Izegahi Edwards, who was indicted by the Economic and Financial Crime Commission (EFCC). Documents seen by reporters showed that Edwards did not represent the Association of Local Governments of Nigeria (ALGON) as claimed. A letter dated August 1, 2018 by the former EFCC chairman Ibrahim Magu to the Ministry of Justice / the Attorney General Office indicted him of an attempt to defraud the Nigerian government. It said the suspect had filed application in court to be joined as one of the judgment creditors during the garnishing proceedings, and the application were refused by the Federal High Court. The judge, in a ruling delivered on the 27th of June 2016, frowned at Dr. Ted Edwards for brandishing a judgment purportedly delivered by the Federal Capital Territory on 30th October 2015 and in fact took a swipe at it. By the motion ex parte filed on the 30th of March 2015, judgment creditor applied for a garnishing order NISI, which was granted on the 1st April 2015 and fixed the return date for 16 April for the garnishee to show cause why the order NISI should not be made absolute. The Honorable Judge, in his ruling, stated unequivocally that, "Let me state right away that the substantive matter was commenced by me until I entered the judgment on the 3rd of December 2013. I have searched my records up to the date of I entered the judgment. I could not find the name of Dr. Ted Izegahi Edwards as representing the judgment creditors even for one day, nor did I find any process filed by his law firm. How then was that judgment prosecuted?" Another point to highlight is that the fact that, according to the purported letter of engagement being bandied by Dr. Ted Edwards, he was engaged in September 15, 2011, long before the matter was filed in court, quoting the exact judgment sum. What this throws up is the fact that the said letter of engagement was done after 3rd December 2013 and backdated to make it look as if the suspect had been engaged before the case started. There is no evidence to prove that the suspect did any works in relation to the recovery process. A careful look at the memorandum of the settlements Dr. Ted Izegahi Edwards and Honorable Odunayo Ategboro betrays the conspiracy and an attempt to defraud the federal government by the suspects. Pending actions, invitation and or arrest of the suspect, Dr. Ted Edwards, with a view of confronting him with all the issues raised in the evaluation above, tracing and filing interim forfeiture order on any property or asset acquired with proceeds of fraud by Dr. Ted Edwards. Reporters gathered that, despite the report, Malãmi persuaded Buhari to approve $459 million as legal fees to Edward. They also directed the DMO and the Ministry of Finance to release the promissory notes to Edward and others so that they could take their shares, a source had said. Edward was the Secretary General of Algon when the Paris Club refund case FHC ABJ CS 130-2013 was done by Joe Agee, San, and his colleague before Justice Ademola. It is clear that he was not the lawyer to Algon, and this much Algon has said in writing to Malãmi and the Chief of Staff Gambari. The EFCC, in its report to Malãmi and Ibrahim Gambari, also established that Ted Edward did not represent Algon, and that Ted Edward, in his own handwriting, admitted that Joe Agee was the lead counsel for Algon. He went to one judge, Baba Yusuf, and procured a judgment that he was the lawyer of Algon in the Paris Club refund case. Yes, Malãmi, who knows this, is recommending that Ted Edward has paid $159 million as fees from Algon instead of the actual lawyer. Will this not amount to double payment whenever Mr. Joe Agee demands to be paid? From my investigation, Mr. Joe Agee, Algon, and the Nigeria Governor Forum have all gone back to the court to challenge the payment of the $418 million, including that of Edward, through promissory notes.